Welcome, ladies and gentlemen, to another episode of Lassiter Law. I'm here with my co-host, Lacey G.
And I'm here with the great, the wonderful, the thorough, the attention to detail, Mark Lassiter.
Lacey, has anything happened since the last time we spoke? I think you said you had mentioned you would watch the Martha Stewart documentary.
Yes, it was fascinating. It was new news to me, and I have learned so much from you that then watching the documentary and hearing some of the stuff that she was saying, I was like, that's what Mark Lassiter's been talking about.
Well, I'm going to be watching that because of your recommendation, but I'm fascinated to see kind of how they portray things because I think that I may have ruined you for legal shows. Have you ever heard of that show Suits?
Yes.
Yeah, I'm totally ruined it for so many people because they ask me, "Hey, is this true? Is this really happen?" I'm like, "No, it is not even close."
So never watch the legal dramas.
Well, no, I love watching the comedy legal dramas. Like, have you ever seen Boston Legal?
Mm-hmm.
All right, so Boston Legal starts out with a real serious, they're dealing with serious cases, they're going to court and they're acting like these are real arguments. And then it morphs and they realize what they are. They're a parody of law. So what they do is they switch it and they become just a comedy and they're taking cases that make no sense that you would never have. And they're making arguments you'd never be allowed to do and statements to judges that you get thrown in jail for. So yeah, I enjoy that type of thing because then I can laugh about it. But if you see a show like Suits or let's say more to the point, Law and Order, that's such crap because you got
Entertainment purposes.
yeah, it's just entertainment. Like this is not what happens. You have prosecutors that are heavily involved with the interview of witnesses and the case, and they're checking the law enforcement's checking with them on a daily basis on what to do. They're making deals based on stuff that would never happen. They're talking to defendants without the attorneys or with the attorneys and saying, do this or else. I'm like, this would never, ever happen. So people think that's true. And a lot of the time in jury selection, I have to tell them that's not what's going to happen. That's not what you're going to see.
I'm seeing bigger picture here.
But
Mark
there's a little trick.
Mhm.
You see, you have to know how to utilize those things. Have you ever heard of CSI? I mean, there's just CSI everything, right?
Mhm.
Well, most people have seen or heard or done something with CSI on TV. Well, you can use that, for instance, to say, look, even on TV, we know that you have a capability of doing this, this, and this. Did you do any of that stuff? Right? Knowing full well that there's no capability for the law enforcement to do any of those things because the cost is so enormous that politically speaking, they don't have the funding to do the things that you see on CSI. But I, the defense attorney, can point that out in a trial and say, look, did you measure the footprint? Did you compare the boot size and imprint to my client's shoes that were right in the corner? I mean, this type of thing.
You are always learning. You are always learning. But I am hearing bigger picture, next step. First, this podcast. Second, you need to be in TV shows. You need to be directing and writing up the TV shows so it's accurate.
I actually, if we're going to go back, was offered a role in basically the TV show would be this. It would be following me around as the defense attorney in some of my active cases. And then on TV, we would show literally what would happen from this point to this point, what we were doing, why we were doing that. And I had to turn it down because even though I thought it would be exciting, cases normally take, anywhere from 6 months to 2 years, which is what we're going to talk about today, actually. So it lends itself right into it. We're going to talk about speedy trial claims and why your case has a right to go to speedy trial. But the show would have to follow the actual progression of the case. And if you were to, in order for a TV show to work, you have to like the person in it. There has to be a hero and a villain, right?
And a wrap up. You need it done, and
you need some sort of conclusion to the case. And so the television company wanted me to have cases that had only already been set for trial. And whereas that's fine, as you're going to see and you're going to hear today, a lot of the trials get reset over and over and over again due to crowded court dockets or witnesses that are unavailable. And so you cannot guarantee, it's not like a special setting with these very political cases where you can guarantee the case is going to go to trial on this particular date and time. So it's hard to wrap up. And then the show is delayed. The season is delayed because you don't have an outcome for that one particular client. And that client has to be willing to be on TV. Most people don't want their criminal charges broadcast to the nation. And whereas I think I would be very entertaining and exciting and all of that stuff, you also have to factor in that the courtroom doesn't want those things. So they're going to act a little differently than normal. The officers may act a little differently than normal. The prosecution may act differently than normal. And at the end of the day, that may end up hurting your client's case, because if a prosecutor knows they're going to be on TV, what are they going to do as opposed to what they would normally do? They're going to pay attention, and they're going to try and make sure that they do the job that I know that they normally don't do. So at the end of the day, I had to turn it down because I thought it will end up hurting my client. Now, if this is a fake TV show, if it's one of those things, for instance, that lawyer in Florida, they did that case with the mom that had drowned her children, I believe, and they got a not guilty verdict on it. And then he became nationally known, and in reality, they never thought they had a chance to win. It was a poor effort on the part of the prosecution. He ends up winning. Then he becomes nationally known, and really he was just an appellate lawyer before that. And then he does a TV show with Fox on like presenting a fake case to a jury, and then the jury would be the audience, and they would all vote for what they would do. I thought that was an interesting concept, but maybe the wrong lawyers were involved because it wasn't interesting anymore. And it's a lot more fun if you do it as more of a comedic and use some licensing there. So that's why those TV shows with lawyers work outside of the actual practice of law.
Heart of gold right here. Turned down a great opportunity because he wanted his clients to get the best outcome. And that's something that you have to screen for in a lawyer, is someone who is going to care and is going to treat you like family. Now, I have different morals, and as your manager, I'm now your manager.
Oh,
I'm moving up. Yeah.
Yeah, so we moved up from co-host to manager.
Yeah. As your manager, I think you should be on TV because I'm fascinated by you on this podcast.
Well, you got to go out and get me a TV show that works, maybe another Suits or something like that.
Okay.
Right?
Okay. I'm on it.
Instead of Harvey, I'll substitute in like a substitute actor.
I'm trying to retire, Mr. Mark Lassiter.
I'll take it. All right, so that leads us to our topic today, speedy trial. So, Lacey, if I were to tell you, you have a right to a speedy trial, what does that even mean to you, the layman, the normal citizen?
Well, speedy trial means we would hope that it would hurry up and happen, that we're not going to drag this out over the years. You mentioned in a previous episode that someone had an ankle monitor on because they were awaiting
Correct.
trial. So if something like that's hindering, or I don't know if health or family death or something like that could come into play, some reason that you need to hurry up and get a solution so you don't have this hanging over your head for however long.
Sure. But do you know what guarantees you the right to a speedy trial? You, the citizen, do you know why you have that right? Where does that come from?
I don't know.
See, this is why we're doing this, to educate the public. So the right comes from the Constitution. The Constitution of the United States says you have a right to a speedy trial of any charge against you. Now, just think about that. Go back. We're talking about 1790s when they come up with this, right? People that have never had anything to do with the legal system, because most of them are farmers, and the legal system really didn't exist because you have an English government, and an English government was governed by William Blackstone, and his theories and common law back in the day. They literally made a document that still makes sense today. That's what people sit here and they question why we have our Constitution, and it's antiquated and it's out of date, meaning because they couldn't possibly comprehend the world that we live in today. And what's crazy about it is if you actually read it and the initial amendments, this is a Sixth Amendment right. This is one of the initial amendments. 1, 2, 3, 4, 5, 6. They said you have a right to confront your accusers. So somebody can't just say it and be anonymous, right? How many times do we see anonymous sources in the news today? That is such BS. If you have a source, be proud of what you are saying. Otherwise, don't say it, right? Know that what you are saying is true. Don't be anonymous, but that's what the news organizations have to protect their witness, supposedly, from some sort of repercussion. No, if you have the balls to say it, say it, right? I get in trouble all the time because I'm uncouth, so to speak, because I speak my mind. Well, there's a reason that I speak my mind is because in this country, I think we've gone too far to the other side and that we're unwilling to speak truth just because we think it will hurt somebody's feelings. Almost any statement that I make anywhere can be taken out of context and hurt somebody's feelings. You can't live your life making statements worried about whether or not it's going to hurt that person's feelings or that person's feelings. You have to speak truth. We've gotten so far away from that that now speaking in untruths is the norm, right? We can't do that. But our Constitution actually contemplated how this could affect people in the future. And 200 and some years later, it is still working. And so when we say the right to a speedy trial, what that means under the Constitution is you have a right for this case to proceed in a timely manner so that it doesn't hang over your head. And there's a lot of reasons for that because, Lacey, what happens if you're worried about potentially going to jail because somebody, not because you did, but because somebody accused you of a crime? How would
Stress
that,
city.
right?
Yeah.
What could that lead to? Anxiety,
Mm-hmm.
depression. You don't know what's going to happen or when or how or why. You have a right to these things. And so what I want to talk about today is what happens in many cases. Now, a normal case, the way it should work is the police investigate. Let's just say, let's relate it to a DWI. They see you, they investigate you, they decide that you're driving while intoxicated that night based on probable cause. Remember in the earlier episode on probable cause, the second lowest burden of proof we have in the country. But the officer gets to form that opinion, and that opinion constitutes probable cause if it's based on specific articulable facts. So now the officer has made his decision, and he decides to arrest you. All right? In the right to a speedy trial, we have what's called a triggering point. A triggering point, ladies and gentlemen, and attorneys out there, is either the arrest or the charging instrument, whether that be an information in a misdemeanor in the state of Texas or an indictment for a felony or the arrest. Any one of those things that happen is called a triggering point. The reason this is important is because if you don't go back to your triggering point, that is when the time for speedy trial begins to run. So let's say, for instance, the officer in that example, he decides to arrest you. Your triggering point is that moment in time. Let's say he doesn't decide to arrest you and he decides, I'm still under investigation. I'm going to wait to arrest until, let's say, this never happens, but I get a blood test result back. And then he gets a blood test result back, but he doesn't actually do anything for a year. He doesn't arrest you and he doesn't charge you. And then out of the blue, a year later, you get arrested because you're driving down the road and you get pulled over for speeding. And he goes, I'm got a warrant for a DWI. And you're like, wait, what?
Mm-hmm.
From when? And then you've already forgotten about it. The triggering point is the date of arrest or charging information. So your start of your speedy trial right does not begin until then. Now, is that fair? What if the officer on a case that has no statute of limitations like child sexual assault, what if he's 10 years later? Is that fair? They've known about the accusations for 10 years, but they simply did nothing on it? No, it's not really fair, but that's what the courts, in specific, the Court of Criminal Appeals has decided, and the Supreme Court has decided this is the triggering point. So even though I believe that the founders believed differently, And if you ask me versus most of the Supreme Court decisions out there, we're going to differ on the Supreme Court because they have political differences. And it's unfortunate because we have these Democrats and Republicans, and they say who has the majority in the Supreme Court. The conservatives do at this time, but it was Democrats in the past. They're voting politically. This is not right. They should vote based on the Constitution and what the law states. What is the plain language? But so often I see the judges trying to justify an outcome, and then they ignore the plain language of the statute or the plain language of the Constitution, and they just make a ruling just made up.
I need to try to get one of those Constitution guys on the show sometime.
Absolutely. I would love to talk to them about, and really anybody. I'll go toe-to-toe with anybody and decide, hey, let's look at this document. Does it still work? Why does it still work? How did they know it would work? I mean, if you are not a student of history, you are doomed to repeat it. But when we're talking about speedy trial, we're talking about that triggering point. That's the first thing that you must look at, attorneys. You must look at what the triggering point is. So let's take that example that I gave you and say your triggering point is the arrest, right? The officer on a DWI decides to arrest you that evening. All right. What happens next? Well, the next thing that's supposed to happen is the case will then get sent to your blood test, will get sent to a lab if there's a blood test, or if there's not a blood test and there's a breath test, you have the result right away. It gets sent from the police department over to the DA's office. Now, so often what we have is delay because the DA's office didn't receive it from the police department. Let's say the police department just never gave it to the DA's office for like a year. You go back to your triggering point, okay? And so that leads us to the first element. So there's a case that's called Barker. And a Barker case is a Supreme Court case. And in that case, they laid out, the Supreme Court of the United States laid out the factors that are to be considered when a court determines if your right to a speedy trial has been violated. And the first factor that you have to look at is the length of the delay. You don't even get to a speedy trial analysis, and your case can be dismissed if your speedy trial rights have been violated. You don't even get to the analysis unless from the triggering point, you have enough time that has passed to indicate there might be a speedy trial violation. So it's triggered by the passage of time.
Is it a certain amount of time? Is it by case? What determines this?
Excellent question. It is a certain amount of time, and it is a case by case. It is both.
Okay.
All right. So this is the first factor. All right. So let's just take them one step at a time. So we're going to take the first factor. First factor being length of delay. When we talk about length of delay, how long a delay is sufficient? Well, the Texas courts, and every state is different, the Texas courts have determined that in small misdemeanor minor cases, so misdemeanors, an 8-month delay from the date of arrest or charging instrument is a sufficient to trigger the analysis. All right. So we have to go back to the triggering point, which is arrest or charging instrument. And then we ask, has there been 8 months of delay? Now, here's the interesting point. Delay until what? Is it delay until the case being set? Is it delay until the case went to trial? Is it delay until you got discovery? What is the delay?
I would think trial till you go to trial.
Absolutely correct. So the trial date is the date that matters. So let's say, for instance, we haven't even set the case for trial and it's been 8 months. Now we have to look at the delay. All right. So first, we look at the triggering point. Second, we look at, has there been at least 8 months on a misdemeanor or potentially longer? The Supreme Court in Barker said when it approaches 1 year, there has been a presumptive prejudice to your case and the delay has triggered a Barker analysis. All right. So usually what I tell people is 8 months is sufficient, but wait a year before you start making any headway on this, before you start bringing a motion to dismiss. All right. So the first factor, length of delay, has it been at least 8 months on a misdemeanor or has it been approaching a year on a felony? All right. So when you have this, What happens next, right? When you have this delay, because delay is for a lot of different reasons. Okay. So for instance, if I had, let's say, 6 months of delay from the date of arrest until the time that the state filed the case, that's actually not a lot of delay, and it doesn't trigger a Barker analysis. But then let's say I asked for discovery and I didn't get it for another 6 months. What happens then? Well, now we have a year delay from the time that the case has the triggering point of arrest and the time that I haven't been to trial yet. So if we have a year, now we have the triggering analysis and we have met the factor of there has been at least X amount of delay. Make sense? All right. So length of delay is the first factor. It's really simple. It's have you gotten at least 8 months on a misdemeanor or have you gotten close to a year on a felony? All right. So let's say you're there. What happens next? Just logically speaking, Lacey, what do you think a court should do when they're analyzing delay, right? What's the next step logically?
I would think that they would have to see what is causing the delay and if that's sufficient to keep the delay. If that's a reasonable reason, I guess, to keep the delay. What is the whole
Justify it. You got to justify it, right? Like, why is there a delay? Now, that actually leads us to the second factor. But before we move on, it's important when you, the attorney, and I'm speaking to the attorneys now, are doing a motion. And when you write this motion to dismiss, because you don't write the motion to dismiss until you're ready to have this heard by a court. So I'm going to take a recent example that we had. We had a case where the individual was charged with sexual assault of a child. All right. Like horrible offense. The outcry for the case was made 8 years after the events occurred. But here's what you need to know, ladies and gentlemen. There is no statute of limitations when it comes to child sexual assault. Now there's some variations to that if you have, a DNA that was never taken. But before going into all that, let's stick with the example. You have a statute of limitations that has not been met, which means they can still proceed with the case. Then after this 8 years, the individual makes an outcry, and then the defendant is arrested. My client was arrested right away, like within a few days of the outcry being made. That 8 years does not count because the triggering point was not met. All right. And we're going to use this example all the way through. So stay with me here. So 8 years have passed. He can't do anything about it. Obviously, there's missing evidence because he could have proven on this date and this time when the individual said that this sexual assault occurred, he wasn't even in the country. And those records are now gone because it's been so long. But none of that matters. What matters is the triggering point. So now we have a triggering point, right? 8 months then passed between the time of the triggering point, the arrest, and the indictment on the case. So 8 months passed, nothing is done. Now we know, like we stated before, that 8 months is the triggering point on minor offenses. This is obviously not a minor offense. So what do you do then? What do you do to argue that the triggering point happened at 8 months? Well, you establish that no further investigation was done on the case. Therefore, there was no need for any delay. Now, if they needed to investigate the case after the arrest because it was complicated and it was conspiracy and involved 40 different victims and 100 different people, co-defendants, that's one thing. But this is not a complicated case. This is a person made an outcry 8 years after the fact. The police believed it. They arrested because they formed an opinion that the client did it. My client did it. And then he bonded out, and then they just did nothing for 8 months. So there is a argument to be made that this is not that difficult of a case that needed an 8-month delay. So now we argue that that's the triggering point. Now, what you attorneys need to know is that if you can argue that any time in addition to the triggering point, makes it more prejudicial. And the factor, because these factors are weighed, either neutral, for the defendant, against the defendant, heavily for or heavily against. So you want to argue that any additional, and there's a case directly on point that states that if you have doubled the triggering date, in other words, if you have double the amount of time that it takes to trigger the Barker analysis, in this case, we had 8 months of delay that was from the time of arrest to the indictment, and then we had an additional 8 months of delay in the time it took just to get discovery from the state. We kept saying, please give us discovery, which means the facts of the case that the state has, police reports, videos, whatever you have. They took 8 months to give that to me. So if you took 8 months to give it to me, now we have a 16-month delay, and we have doubled the amount of time necessary to even trigger a Barker analysis. So at the end of this factor, ladies and gentlemen and attorneys, you need to put the time after the triggering date. And because in this case we had double the amount of time, we use the case that says double the amount of time should weigh heavily against the state. Now, we'll get to justifying the delay in a minute, but when we finish up this first factor, it's important that you point out for the court the case law that backs you up. This is the attention to detail, Lacey. You say, here's where we started, here's where we are now, here's the reason, and because the triggering point was so far this way, then this factor needs to weigh heavily against the state. So in that particular example, it was double the amount of time. We argue it weighs heavily against the state because it's not an overly complex case. All right, that brings us to the second factor. The second factor is the reason for the delay, just like you said, and the state bears the burden to justify it. So let's just say, normal person, what things can you think of that might cause a delay that the state can say, hey, judge, we couldn't move forward because this reason, this reason, this reason. What reasons do you think they might be?
That they're still investigating the evidence, that they're looking into the evidence.
Excellent.
Unable to get.
Excellent.
Yeah.
So they argue that all the time. Judge, we had to investigate the evidence. I always ask them, I just kind of look slyly at the judge and I say, okay, let's assume that that's true. Then why did they make the arrest? Or why did they issue an indictment? If you needed more time to investigate, that means your investigation was not complete. And if your investigation is not complete, then what do we know? Judge, ladies and gentlemen of the jury, we know that they didn't do their jobs. We know that they acted rashly. They put the cart before the horse. Just thinking in terms of common sense, I would think the investigation comes before the arrest. Right? And you can play coy with that. Now, the judges don't appreciate that. They don't like the theatrics, but guess who does?
The jury.
Juries.
Mm-hmm.
That's right, because they don't understand why there's a delay.
And the TV viewers, too.
And guess what? They're right. The judges that say, oh, it's part of the process are wrong. They are part of the system that is wrong. You see, if they were doing it thinking in terms of the way that it is supposed to work, you are not supposed to put the cart before the horse. If you act, now, here's the difference between federal and state court. In federal court, they have a certain amount of time after they make the arrest to do an indictment and then go to trial. They are given a trial date almost immediately upon release. You're either detained or you're not in federal court, and then the judge gives you a pretrial date, pretrial conference, trial date right off the bat. They don't do that in state court. And the reason they don't do that in state court is many times these officers are not done investigating. So what are you doing arresting? Investigate first. I don't think that's so hard to do. Now, all of this to say, that is a common excuse, and that's a way to combat that, all right? Think of other common excuses that they use. Let's just relate this to DWIs. Many times they say, well, we needed time before, even though the arrest had been made by the police department, we, the district attorney, had not accepted the case yet because, like I said before, the police department never sent it to us to accept. So many people don't know this. When an officer makes an arrest, that does not mean you will be prosecuted. It means that the officer feels He has an opinion that you did something wrong. He then sends his report to the district attorney. In a misdemeanor case, the district attorney accepts the case and then files the case with the county clerk. That is how a case gets filed. And then with that filing, you have a formal charging instrument, the information. For a felony, the formal charging instrument is the indictment. And so if you never get the case from the police department, you, the prosecutor, say, well, Judge, we never got the case. That's the reason that we had 8 months or a year of delay. So do you think that that is a valid excuse? Do you think that should be a valid excuse, Lacey?
No.
I agree with you 100%. Now, initially, it was held to be a valid excuse until the justices in the courts of appeals and in the Court of Criminal Appeals came down and finally said, no, you are part of the state of Texas. You are the government. Anything that is not the defendant is the government. So any delay, whether it's the police department, whether it's the labs, because sometimes they wait a long time to get the lab test results back, and then they use that as an excuse, doesn't matter what it is. If it is not the defendant's delay, it is the state's delay. So government agency delay is attributable to the state. You, the attorneys, need to know that, cite the case law, make sure it's in your brief.
Because that just means they're not doing their job, and that's not the defendant's
That's right.
fault.
Anything that is not the defendant's fault is state delay. And ladies and gentlemen, lawyers that are out there, try and put into your brief these things so that you don't have to go looking for them. And you don't have to do this every time. The same briefing will work over and over again, but you have to make sure the case law is still valid, which means keeping up with the current state of the cases out of the Court of Appeals. But still, you need to put this there so that you don't have to go looking for it when you're arguing to the judge, and the judge says, well, why should I not consider this to be neutral delay? Judge, did you read my brief? You want to make sure the judge has read your brief, because why write something if nobody's going to look at it? So the first thing that I always do is ask the judge, hey, did you have time to look at and read thoroughly the briefing that I provided the court? It has all of the relevant case law. It illustrates to the court why there has been a violation in this case. And then they go, oh no, give me a second. And then they'll read it right then and there, because most of the time they don't have time to do it, or they don't know to do it. So if the judge reads my brief right before he starts a hearing, what have we just done?
Showed that they haven't done
No,
their job.
practically speaking, I know the judge hadn't read it before, but practically speaking, you have now allowed me, the defense attorney, to argue twice. Because now the judge reads all this case law, and we write in a way that is persuasive. If you're writing bland, neutral briefing, then you're not doing your job as an attorney. The whole purpose of your goal is to be persuasive to whatever side point of view that you have. Now, I'm not saying misrepresent cases, because that would be persuasive for you to not have those cases. You need to represent them fairly, but you need to argue why it applies in your case. And in this case, your constitutional rights were violated. So in this case, when there's been over a year delay and the judge is reading my briefing in the hearing, he is essentially hearing me argue. Then he's going to listen to the state. So he's going to be, or she is going to be, somewhat biased to listen to them, because they're going, wait a minute, that doesn't match up with the case law that I just read from this Court of Appeals. So that excuse doesn't work. Prosecutor, XXX, try again. All right? So that's really important. So you got to know your audience. And this might seem like a little trick, but it's not. What you have is, hey, you need to follow the law. And I'll give you a perfect example. I got called the other day by an attorney, and this attorney was having a problem because he needed a continuance in a case because he needed to get certain items done, but he couldn't figure out how to get one because the judge had already told him, your case is special set, you will get no more settings. Well, I asked him about the case a little bit and found that the charging instrument was incorrect. It had listed a couple of things without specificity. I said, well, why don't you just file what's known as a motion to quash? And he goes, "Oh, no, 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 no. The prosecutor will hate me." Well, what do you care? The whole purpose of this is to do your right by your client. Now, the client was not particularly, let's call it sympathetic because of the type of charge and the amount of them, but he followed my advice. The judge granted the motion to quash, which then made the state get a continuance so that they could fix the problem with their charging instrument. And he called me back and he said they were so upset, but it worked. And I was telling my wife about this, and she goes, "Isn't it?" And then the attorney had said, "I guess I'm going to subscribe to the Mark Lassiter practice of law now, which is piss everybody off." And I said, "I don't know why this is, but why does everybody feel that simply following the law, and that pisses off the state of Texas, the prosecutor's office many times, is somehow, uh, let's call it controversial?"
Because other people don't do a thorough job and have the attention to detail. So whenever you're the smart kid in class, then that could annoy the teacher.
Well, it annoys the teacher, and it annoys, in this case, the other students in that particular example, but it annoys the state of Texas most of the time because you're pointing out something that they didn't do that they should have done, and it makes them look bad. And then everybody hates you and thinks you're some sort of a prick. But at the end of the day, what did you really do? All you did was ask the judge to follow the language, plain language of the statute and the law. And somehow that develops you a reputation for being difficult to deal with. So I always found that fascinating, that attorneys look down upon you for asking the judge to follow the plain language of the law. But all of this to say, where we're going with this is when we're talking about the second reason, which is justifying delay, do not let the state of Texas make some excuse and then let it stand. You need to show, whatever that excuse happens to be, that that's not a valid excuse. And you use the case law that is provided by the Court of Criminal Appeals that says the burden rests solely on the state to justify a presumptively prejudicial delay. So they need to justify it. And saying, "I'm sorry, Judge, we didn't get to it, crowded court docket," that's not good enough. Saying, "I'm sorry, Judge, I didn't have time to give discovery to the defense attorney," not good enough. "I'm sorry, Judge, we didn't have time to properly investigate this case before this," not good enough. "I'm sorry, Judge, the police department never gave us this case," not good enough. "I'm sorry, Judge, we didn't get the lab results back on either a DWI or a drug test showing that they were over the legal limit," not good enough. Basically, there is nothing that can justify this delay other than what? A seriously complex case that involves multiple witnesses that were not able to be obtained due to no fault. Let's say you have a police officer in your example that you got arrested for DWI. Your police officer got deployed overseas. Well, that's not something that anyone could predict, and he is a necessary witness for your case. In that particular circumstance, I think the judge would say that's a justifiable delay. That's not the fault of the state of Texas. That is the federal government sending him overseas. Now, it can't be forever, and you can set it right as soon as they get back. But at the end of the day, what you need to know is that they need to justify it. So there is also what you need to know, attorneys, is there was a recent case from the Court of Criminal Appeals called Heath. And this is a case that dealt with discovery. And in Heath, the court ruled that the state has an obligation to seek out information that you ask for. And if they don't provide it timely, that is called willful conduct. In other words, you asked, they didn't do, that is willful. Now, how does that matter in speedy trial and justifying the delay? So I'm going to go back to our example. We have an 8-month delay due to the arrest and the indictment being filed. Nothing happened during that time. And then we had an 8-month delay because the state didn't provide discovery. Well, under the Heath case in the Court of Criminal Appeals, I can now say, Judge, that is considered willful conduct. Now, why does that matter? Because the case law is very clear that willful conduct will count strongly against the state of Texas, whereas negligent conduct, like for instance, they just forgot, will only consider slightly in favor of the defendant. So I am able to argue now, based on this case, that if the state doesn't provide discovery when I ask for it, then that is willful conduct by the state of Texas, and it should be counted strongly against. So let's recap. We've got two things. We've got length of delay, which is by the triggering point, which is arrest, indictment, or information. Then you have reason for the delay. Second factor, can they justify it? In almost no circumstances will the state be able to justify that delay unless the case has been set for trial multiple times and missing witnesses and that type of thing. So almost in no cases, if the case has not been set for trial, is there a justifiable delay. Unless you, the defense attorney, request delays. That's one of the things that people don't understand. So going back to our example, I requested 8 months of delay. The state of Texas can go, hey, Mr. Lassiter, if he wanted a trial, he could have set it for trial day one. Well, the interesting part about that is I refute that with, I can't set it for trial because I know nothing about the case, because you haven't given me what the law requires you to do. So you violated a statute for which there is no penalty. In other words, there's no penalty for the prosecution violating a clear-cut, valid statute that is the plain language. However, I get to argue these are not my delays, these are prosecutorial delays. So you, the defense attorney, if you're signing pass slips, know why you're signing them. If you have already gotten discovery from the state and you're signing pass slips, that delay is going to be counted against you. So be aware of that, okay? We need to go to the next. So let's say you've met number one, there's been a more than 8 month delay. You've met number two, the state had no valid reason for the delay. The next factor is, did you ask for a trial? Okay? Because in order to have a speedy trial, you have to want to have a speedy trial. Now, many people
Do you
don't.
ask before or after this has happened?
Excellent question. So let's go back to your example where you were arrested for probable cause on a DWI, and then the officer sends the case over in a normal amount of time, usually takes about a month, to the DA's office. So the DA's office has the case. They provide discovery to your defense attorney. Let's say that's me in this case. We meet, we say, okay, this is a good case for trial. I then have an obligation to set it for trial. I can't complain that I didn't get a trial within X amount of time and not have set the case for trial. Now, there are instances where your right as a citizen to a speedy trial has been violated without even requesting a trial setting because it took too long. So for instance, I'm going to go back to my other example. We had a 16-month delay, a year and 4 months, and we have prejudice because we have a missing witness and the case has not been set for trial. So I'm going to set it for a motion to dismiss because my rights have been violated prior to setting it for trial. Now, that is allowed in certain circumstances because the right has been violated, because there is prejudice, which is the next factor we'll get to in a moment. But you have to have the prejudice before you set it. Now, if you don't have that prejudice, setting it for trial is important. So let's say in your example, I then set it for trial and then it gets moved and then it gets moved and then it gets moved and then it gets moved. And all of the reasons that it got moved were either the courts were crowded or the state was missing a witness or the state hadn't given us information that it needed to use in the trial. Those are all state delays. And now I can use that and say, hey, we've gone through 4 different trial settings, Jones. It's been a year and a half. This has now violated my client's right to a speedy trial. I still have to show prejudice, but the longer the case has gone on, the less prejudice I have to show. So going back to demanding a right, when should you do that? I do that at the earliest opportunity if that is what I want. Most of my clients know right up front kind of what their case is about and whether or not we're going to want a trial. And so I can demand a trial pretty quickly. And I can put a motion in saying, Judge, we want a speedy process, right? We demand a speedy trial at the earliest opportunity. if that is in fact what we want. And that's one of the factors, because if you don't demand it, it doesn't mean that you lose the speedy trial motion. What it means is you may have a neutral weighing of that factor because you never demanded a speedy trial. And if you demand a speedy trial and it's called pro forma, which means you really didn't want a trial, you just wanted a dismissal, many times that will weigh against the defendant. So go back to my previous example with the child sex case, where we had a 16-month delay. And in that particular case, we knew that we wanted a trial. So we asked for a trial the moment he was arrested. And then we asked for a trial the moment the indictment happened. And then we asked for a trial at almost every setting. Now we've established that we want a trial. So it's no longer a what's known as pro forma request. That doesn't stop the state from sometimes arguing, oh, he really didn't want a trial because he never set the case for trial. Well, we didn't set the case for trial because we didn't have discovery. We wanted one, but we needed discovery first so that we would know what we're going to trial on. The judges will understand that. So it's no longer a pro forma request. So attorneys out there, understand you're going to have to challenge, you're going to have to respond to those accusations by the prosecution. He doesn't really want a trial. Be prepared to explain why you wanted a trial, how you wanted a trial, what prevented you from setting it for trial. So that's the third factor. And in fact, it's the least important factor, because if you can have a right violated, the speedy trial right violated, without that factor even being asked for, without you even having, hey, judge, I'd like a speedy trial, that makes it the least important of the four factors. And then the last factor is prejudice. Now, the courts have said this is to be given the most weight. And that makes sense, because the whole point of the right to a speedy trial is so that you don't have a worse case today than you would have had that right not been violated, had it gone to trial in a timely manner, right? And what is a timely manner? We've talked about it. You go back to the first factor, within 8 months or within a year, right? Those are the real basic formulations for that. So when we say, what is prejudice? Well, the Supreme Court and the Court of Criminal Appeals kind of agree with this, because the whole reason that we want to have speedy trials is so, one, you don't spend too long in jail. Some people cannot afford a bond. And if you can't afford a bond and you're just sitting in jail, this is the right to be free from oppressive pretrial incarceration, because you're doing time for something you may not have done. So you have that right. That's the first thing. The second thing is to minimize the accused anxiety. Even we, Mac, and I'd love to read a statement for you that I put in every single one of my cases. And it is an excellent, excellent synopsis of what happens when you have anxiety. Okay? This is from the Court of Criminal Appeals. One of the major evils, think about that. They called it a major evil, highest court in Texas. The speedy trial right is meant to protect against is prolonged anxiety. And they followed this up with the sword of Damocles weighs no less merely because the source of anxiety is the appellant's fear of conviction and the resultant as yet unknown punishment. If you think about that statement, what they are saying, and this is a Greek statement, is that you don't have less anxiety simply because you're fearing your conviction or you're fearing possible incarceration. Doesn't make the anxiety any less. Even if there is something true to it, you still have that anxiety, which has to be dealt with, and sometimes in very, very horrible ways. And I have yet to have a client do this, but I had somebody else ask me about this. Is they had a client that was mentally ill, and they were accused of a crime that they claimed they didn't commit. And then, because it had been nearly 2 years from the date of the arrest until the date of the trial for which the trial was set, the client took their life. And they took it because they couldn't handle the stress, because it kept getting reset over and over and over again. You can't bring that person back. There's no redos. There's no judge that you should have granted that motion to dismiss for speedy trial. So anxiety is real, and it's becoming more and more real in our society. Now, whether I think that's because big pharma wants to put you on all these blockers and you have all of these different antidepressants because that seems to be the cure-all for everything. If you're depressed, oh, take an antidepressant. Most people don't understand the antidepressant doesn't always work. It's different. Every person's chemistry is different, personal chemistry. And so if you get on one antidepressant, it might make you worse.
You still have to try out different medicines to get the right fit. It's not just a one pill for everyone.
That's right. And truthfully, I don't like the pills to begin with, but I had a client that really needed something, and they put him on a cocktail, like 11 different pills. And then he would go nuts if one of those combinations went off, because when you take one pill, it affects one part of your chemistry. If you take another, it's to fix what that pill did to help you out your brain, but that ruins your liver. And then you have to take this liver pill, which ruins your heart. And it's a really damning exercise to go through, which is why I really don't like taking pills of any form. And if you go back to the history of it, and I can only hope that they will change this, is that Big Pharma, the reason that people don't trust Big Pharma, and let's be honest, these people kill people. Do you remember Vioxx? Like, they killed people, and then they made $12 billion, and they paid hardly any, like a couple of billion in fine. That's a $10 billion profit. Yeah, we'll take that deal, right? These are industries that are known for putting out products. If you ever heard, like, at the end of a commercial when they say all of the bad side effects,
Yes, sir. I come from radio. I've had to do all that speed it up so you can't hear it. Yeah.
do you know who the biggest proponent of commercials, radio, and television is?
Big pharma?
Pharmaceutical companies. Do you know why?
Why?
So that the investigators or the reporters don't look at them. That's their biggest meal ticket. That's their biggest donor, in essence. That's their biggest person that we go to, their biggest client that they sell ad space to. They do this so that they don't get told about in the news and say, hey, this is a bad company. They put out bad products. They will kill you. Be careful. They don't want that. And they make billions. They don't care. The spending is everywhere. Okay? Just next time you're watching TV, count the number of pharmaceutical commercials compared to anything else. You will be astonished. All right, that's my pulpit for the day. But all right, going back to how it relates to speedy trial, that's the anxiety factor. All right, and then the last is prejudice. Most people don't understand how to argue this. The law is clear. You have presumptive prejudice. What does that mean to you, Lacey? If I were to say something is presumptively prejudicial, where do we start with that?
I wouldn't know where to start. I mean, a good example that you had earlier was they were arrested, but then still searching for the evidence. Then that would seem to be prejudice to me, because why are you arresting if you don't have the evidence?
That's an excellent point, but we're talking presumptive. So presumptive, if we just take that word, it means that it is presumed. That means the court should presume, after the triggering point has been met and the length of delay has been met, that your case has been prejudiced, because as time goes on, the courts have ruled that your case can become prejudiced in ways that we can't even know about. You don't even know how your case has been prejudiced by the delay sometimes. So presumptive prejudice means that there is prejudice and the state must overcome it. Now, the case law is clear that as the length of delay goes higher and higher and higher, the need for establishing prejudice is lower and lower and lower. But most people don't understand to start the court with there is presumptive prejudice. Presumptive. That means this state must battle it. They must show that there is no and they can do that. They can say, hey, there's no prejudice because this witness is now available if you had a missing witness. Hey, there's no prejudice because we have the lab results that were no longer that weren't available before. We have this drug test result that wasn't available before. That's how you would combat it, but they need to combat that because it is presumptive. The law from the Court of Criminal or law from the Supreme Court, a showing of actual prejudice to the defense is not required. It is not required. Start attorneys, your judges off with that. A showing of actual prejudice is not required. Only some showing of potential prejudice is sufficient. If you think about that, all you have to say is, Judge, our case has been presumed prejudicial because of the length of delay, and there are ways in which it could be prejudice which we wouldn't even know about. Just saying that is enough. Now, I don't say stop there. Don't ever stop there. Always give them more in that particular instance, as much as you possibly can, because a lot of the judges around the state of Texas do not understand this right. They feel that if you filed the case within the statute of limitations that matters, oh my gosh, the statute of limitations is not the right to a speedy trial. You cannot violate the statute of limitations and violate the right to a speedy trial. If anybody ever brings up the statute of limitations in a speedy trial hearing, you, the defense attorney, need to jump all over their ass and say, this shows you, Judge, they clearly do not understand what this is about. This is about a Sixth Amendment right to a speedy trial. It has nothing to do with the legislative statute of limitations. The statute of limitations are not based on whether or not a right to a speedy trial has been violated. A speedy trial has been violated when you show the 4 factors. And then a balancing test happens on those factors. We'll get to that in a second. But when we talk about prejudice, some of the easy ways to show prejudice for anxiety are specific anxiety, not generalized. Specific to, I couldn't meet my bills. In our case, we had the child sex case. He got fired. He couldn't support his family. So that is specific anxiety about what's going to happen, not generalized on what's going to happen as far as a result of the punishment in the case. Okay? Specific anxiety because of what had happened. Then you show missing witnesses if you can. That's a really easy way, and courts have found that missing witnesses are a very clear indication of prejudice to your case. Missing evidence. If body camera videos have gone missing, if notes from the detective have gone missing, whatever the case may be. We have a case right now that's in Comal County where we had 2 witnesses that would have been able to testify that this didn't happen. The officer saying he approached because they had loud music. They're saying there was no loud music. Those 2 people were afraid of being charged along with my client, so they just disappeared. Well, now, because it's been 3 years, we have presumptive prejudice and actual prejudice, and the state must combat that, which they couldn't. Now, the judge didn't rule in our favor because the judges don't know the law. And even if you tell them the law, what I got back from the judge in that case was, well, this is not long for our county. We have 10-year-old cases. And I was like, the reason, Judge, that you have 10-year-old cases is because you don't follow the law. And the attorneys that you have in your county are not bringing this to your attention. They should be, to show that their rights are consistently being violated in these counties, in these smaller counties. And the judge is like, we don't care. They won't care until you start appealing them, attorneys. Don't be afraid to appeal. That's what they're there for. The law is in your favor if you simply present it properly. So when we talk about presumptive prejudice, one of the other things is the longer the case is delayed, the less prejudice. We've talked about that before. So keep that in mind when you're arguing prejudice. Make sure the judge is aware of that. Okay, now, what happens after you've presented all of the 4 factors? What happens next? Well, normally it's a ruling, but before the judge is to issue a ruling, the case law says the judge must do a balancing test on those factors. So you can lose factors. For instance, the demand for a speedy trial. The judge can rule that factor weighs against the defendant, but because prejudice, the 4th factor, is to be given the greatest weight, he can still rule in your favor because you have actual prejudice that has not been combated, that has not shown to not exist. All right? So the judge is to weigh all those 4 factors and then do a balancing test to decide which side he's going to rule for.
Like the literal legal scale.
Right. That's where the judge will weigh them in his own mind and decide what's what. Now, an important thing to think about is that if all of the factors weigh in the defendant's favor, even if they're only slightly. So let's assume all are slightly in the defendant's favor. Then the judge doesn't have discretion. They must rule for the defendant. And that's really important for you to point out, because I would establish in my case that we used as an example that we had more than an 8-month delay. We had 16 months. So we met the first one. The second one, the reason for the delay, the state has no basis for it. They didn't give us discovery, which is considered willful, so it weighs heavily against them. And then they didn't do anything for 8 months for no apparent reason, because the investigation was done. So that weighs against them. So we win the second factor. We demanded a speedy trial right away. We actually sent a letter of representation to the prosecution's office the day he was arrested saying, we want a trial as soon as possible. They did nothing. So we had a year and a half before the time that he was arrested and we sent the demand, and the time that we filed our motion to dismiss. So that is in our favor. And then we showed that the witness was missing that would have been beneficial for us. So we had prejudice, which they cannot combat. So the fourth factor is in our favor. So the judge must rule for us, right? Maybe. And I'm going to leave the audience with this, my last example. What can happen? How bad can it get? Let me tell you this story. So another client of mine, he was investigated for rape. Horrible crime, right? After 2 years of investigation, DNA tests, DNA matching tests, witness statements, body camera interviews with the defendant, with the complaining witness, and with the friends, because this happened after a bar and they went to his house and they had a good time and she claimed rape the next day because her boyfriend found her, all right, using the Find Your Phone app. All right, so she was upset, and of course she's going to claim rape in order to get out of it, and she's married to that guy now. All right, so all of this happens, and then for 2 years, they don't do anything. Now remember, what is the triggering point, Lacey? We've learned this.
The arrest.
The arrest or
The indictment.
the indictment. Okay, so for 2 years, they did nothing. Not a thing. They did their investigation all within a couple of months, and then nothing happened. And then in the police report, it actually said this: we discovered that we had overlooked the filing of this case. And they sent it to the DA's office, who then indicted the case. So what is our triggering point? It is 2 years after the date of offense. This is a true story, ladies and gentlemen. This could happen to you. This is why it is so important to get the right attorney. So 2 years later, you have the triggering point. Well, the client doesn't know this because they never bothered to serve the warrant. They issue the warrant, but they don't do anything with it. Guess what happens? Years go by. When I say years, I mean 4. 4 years go by where he has a pending rape charge, sexual assault, and he doesn't even know it. You know how he found out?
How?
He was on his honeymoon in a different country, and they arrested him in customs.
Wow.
Can you imagine his wife at that time? They had a great relationship, obviously to the point where she agreed to marry him. They go to this foreign country on their honeymoon, and in the customs, they say, your husband has to come with us. He's been charged with rape. How would you, a brand new wife, feel? Think, Lacey, how would you feel in that situation?
I'm anti-marriage, been there, done that. So I'm not
So you're like,
not
whatever.
worry doing that again. Yeah. But I mean, mortified, curious, horrified.
You don't know what's going on, and they can't
Yeah.
tell you because they don't know. So he gets transferred. It takes 2 weeks to get transferred from customs, from federal custody to state custody, because that's how it goes. It is very difficult. So he spends 2 weeks locked up, barely keeps his job, doesn't even know what he's being charged with. This doesn't even cross his mind.
They don't tell him
No.
when he's under arrest.
They don't. They tell you when you're arraigned back in the States. So eventually he finds out what it is. He's arraigned. He bonds out. And the first thing he does is hire the wrong attorney, unfortunately, who doesn't really do anything. Then he finally switches over to me, and we say, well, clearly your right's been violated because there's evidence missing. We got the police report that literally said we lost the body cameras where we interviewed these witnesses. That may have proved very prejudicial for him because it could have been used to show differences in the stories or untruths or inconsistencies. So clearly it's a benefit to him to have those recordings. So we do the motion. We say, Judge, the delay was 4 years from the time of the indictment. That's the triggering point. It's not 6, it's 4. We say the delay is directly attributable to the state. And they said, no, it's not because he had absconded. And I said, no, you just never served the warrant. You knew where he was the whole time. Here was his address. You had interviewed him at that address. You had the name of his attorney that he had when he was being investigated. You guys did nothing. So the delay was wholly attributable to the state. Then we had demanded a speedy trial. Well, we demanded a speedy trial when I got on board, which was 4 years after the fact. But that shouldn't have mattered because the next step was prejudice, which we clearly showed there was prejudice because the missing recordings. You know what the judge did?
What?
They ruled against us. They said, no, that's not a violation. Because the most important factor to us, judge that clearly doesn't understand the law, is that you demanded a speedy trial, which you didn't until the very last minute. And I explained to the judge, you cannot demand a speedy trial if you don't know that there is a case. And there was a case directly on point that explained to the court that when you don't know there is a case, you cannot hold the lack of a demand for speedy trial against them because they don't even know there's a case. But guess what? That judge didn't care. And this goes back to, ladies and gentlemen, judges will not always agree with you, even if it is in violation of the law, even if it is clearly against the law. So what do you do in that situation?
Attention to detail.
Attention to detail. So in this case, we don't let the decision simply stand. Now, you don't have a right to an appeal on a speedy trial until after there's a resolution with a case. So what you have to go back and do is say to the client, hey, we're going to win the appeal. More than likely, you can't guarantee that, but all the factors are in your favor, so it's very clear in your case. However, there must be a resolution. So do we plead to rape just so we can go to the appeal, or do we go to trial?
Trial.
We go to trial. And here's the problem. When you, the client, then pay your attorney, let's say it's somebody like me, and they win the trial, it doesn't matter what the decision on the speedy trial was. You've got a not guilty, and you can get it off your record. So at the end of the day, I use that example to tell you, the public, and you, the attorneys, you can do everything right, and everything can be in your favor, and you can still not win. You need to know what to do next. And in a lot of my cases, we have appeals going under these issues because the client didn't want to fight the case, didn't want to spend the money in trial, and then we do a plea and then we appeal. So you're allowed to do that once you have a resolution. But you can tell the court we would never have pled except for this. And sometimes the courts will make you waive appeal in order to plead. Attorneys don't do that. Citizens don't do that because if you do, you lose your right to an appeal. So if you have a good speedy trial claim, I mean a good one, not a questionable one, consider very hard whether or not you want to waive appeal because that will negate your ability to win your case. And what are we about here at Lassiter Law, Lacey?
All about winning.
Winning.
All about winning. Mark Lassiter goes hard every time.
So, ladies and gentlemen, that is speedy trial in a nutshell. There are many more nuances. I encourage you to look at how to find the right attorney so that you have an attorney who can understand these nuances. If you have an attorney who does not, have them reach out to me. And ladies and gentlemen, you can reach out to me at mark@lomtl.com, or you can reach me at 214-845-7007.
He's always got that attention to detail, and he's always going to go hard for you. Thank you so much, Mark Lassiter.
Thank you.
ProPod Digital.